Good evening, everyone. Welcome to another Thursday evening edition of Employment Law Q&A. For those of you that don't know me, my name is Alex Lucifero. I am an employment lawyer and partner with Samfiru Tumarkin LLP. As an employment lawyer, day in and day out, what I do for a living is help people resolve their workplace problems. And that's what we're here to do this evening. We're here to help resolve your workplace problems, answer your questions. This is a live Q&A. I'm here right now for the next half hour to help figure out those situations that you're struggling with at work, whether it's related to COVID, and maybe you're dealing with a health and safety issue at work. Maybe you've been laid off from your work because of COVID. Maybe you have questions about vaccines in the workplace. We've certainly been receiving lots of those recently. Or whether you're dealing with anything else unrelated to COVID in the workplace. If you've been let go and you've been offered a severance package, or if your boss is treating you badly, any questions you have about the difficulties that you're having in the workplace, this is the place to get those questions answered. What are your rights? What are your obligations? And what does your employer need to do in order to resolve these workplace issues? If you'd like to get a hold of us, I always share our contact information at the start of each show. Some people are too shy. Some people don't really want to pose their questions online like this. You can reach us at a couple of different places. Visit employmentlawyer.ca if you'd like to visit our website. It's got a ton of resources on it. We've got a ton of blogs, a ton of articles, lots of video clips, really anything to do with employment law. You will find the topic there, either in article format or video format. If you'd like to contact us directly with your specific problem, help@employmentlawyer.ca is the email address. That's help@employmentlawyer.ca. Send us a brief email, give us a description of your situation. Someone will contact you as soon as possible. And I promise you, someone will respond and put you in touch with either one of our lawyers or one of our paralegals, somebody, in order to assist you and get you headed in the right direction. A couple of matters I wanted to talk about this evening to get the ball rolling, get us all kind of warmed up and thinking about employment law issues. I spoke to a very nice gentleman earlier today, and his situation was a good reminder of a situation that sometimes employees will find themselves when they transition to a new job. So I'll tell you a little bit about this gentleman's situation, and I think it provides a good lesson for employees out there who are leaving one job and being recruited away from that job to join another company. This gentleman was with a previous employer for about 4 years, very happy in his employment, quite successful, doing well. His employer liked him. He liked where he worked. And not too long ago, at about I guess the end of last year or the beginning of this year, another employer, a competitor company, actually reached out to him and was interested in recruiting him away from his previous employer. The interest intrigued this person, and he ended up moving away. They effectively enticed him. They offered him a better salary, and they offered him some additional perks and whatnot. And they actually recruited him away from this previous employer, and he joined this new company. Fast forward to earlier this month, or shall I say late in May, things just weren't working out with his current employer. He had only been there for about 2 or 3 months. But they weren't working out. It wasn't what he signed up for. It wasn't what he was promised. And this gentleman's employment was actually terminated. So imagine this is you. You were in a situation where you had been with the same company for 4 years. Things were going great. You're recruited away. You're actually kind of incentivized and enticed away to leave that company, to resign your employment and join this new company. And then 2 months later, they sold you a bill of goods and it's not what you were expecting. 2 months later, you are let go. And so this gentleman was asking, well, am I owed severance just based on these kind of 2 months of service, which, would probably be not all that much. Something feels off here. Something feels unfair about this situation where they basically sold me on this job and then cut me loose 2 months later. And I told him, well, actually, yes, there is legal recourse for somebody in that situation. If you've been enticed or kind of recruited away from employment and incentivized to join this new company and then let go very early on, you may be able to count your previous years of service with the previous employer as your years of service for the purpose of calculating your severance with the new employer. So what I told this gentleman is, well, hold on a sec here. In the eyes of the law, because of everything that went down, you're not necessarily just a 2-month employee. You may very well be a 4-year and 2-month employee. We have to count those previous years of service because you were recruited away. And that meant that this gentleman was going to be owed way more severance than what he would otherwise be owed just with a 2-month package. So it is a good lesson here, not because of this very kind of particular, very nuanced, very technical issue of counting previous years of service, although of course it's extremely important. It's important because, listen, whether you're a 2-month employee or a 20-year employee, it's extremely important to receive legal advice when you're let go from your employment and offered a severance package. You might think it's the fairest severance package in the world, maybe because you're a very short-term employee. But short-term employees also can receive significant severance packages in the way I just described. So again, the lesson for all of you viewing out there is, regardless of what you individually think of your situation, whether you're a very short-term employee or a very long-term employee, or an employee of just a couple of years maybe, if you've been let go, regardless of how you feel about your severance package, there may be factors and circumstances there that change the analysis in the employee's favor. And so do make sure, if you've been let go, that you reach out to us. Happy to have a chat about your situation. Wherever you are in either Ontario or in British Columbia or in Alberta, and we operate in those 3 provinces in Canada. Fortunately, we can't help anybody outside of those provinces. But if you live in one of those provinces, wherever you live, then do be sure to reach out to us. Speak to us about your employment problems. Speak to us about the severance packages you've been offered. Oftentimes, it's our experience that a company's initial severance offer is very, very low, well below what it should be. And we work on a daily basis to get people the severance packages that they're owed. So a little lesson here. I always like to start off our segment with a story like this. It's a real story. I spoke to this gentleman just today. And again, we speak to people every day in these kinds of situations. So hopefully that helps someone out there understand a little bit more, legally speaking, about their own situation. All right, guys, let's get to it. I already see a couple of questions here coming through, which is excellent. Please go ahead and ask me your questions. This is a live Q&A. I am here to help you. I'm here to answer your questions. Have at it. Whatever it has to do with in the workplace, COVID, not COVID, terminations, severance, or anything else for that matter, ask away. I am here to help, and that's primarily what we do. All right, Razor Sharp, I love the name, asks the question, is it legal to record a conversation I have with my boss? Excellent question. It's one that we get asked on a relatively regular basis. Here is the way the law works in Canada, guys. I don't know where you are in the world or where you're watching from. In Canada, if you are a participant in that conversation, if you are one of 2 or maybe even 3 participants in a conversation, you are legally allowed to record it. It's not criminal to record it. Be careful about recording stuff at work. Sometimes it's not a great idea. Maybe you want to get some legal advice before you actually do that. But if you're worried about someone taking advantage of you, or if you're worrying about kind of protecting your kind of basic employment rights, and you want to record a call or record a conversation just to be sure, yes, you absolutely can record it, but be sure to not record other people's conversations. If you're recording a conversation between 2 other people, that may very well be a criminal offense. Obviously, we don't want to go there. And again, the disclaimer I'll insert here is if you're not sure, make sure you get legal advice before you do anything. But it is clear that if you are involved in the conversation, you can record it. All right, Ioana asks, should I wait to get fired or file a case of constructive dismissal as I feel harassed at work? I was told, and I'm sorry, Ioana, I can't see the bottom of the message, but I'll answer it there. If you are being harassed at work, there are a couple of steps that you absolutely must take. Walking away and quitting isn't necessary. Can my employer record my meeting without telling me? No, they can't, Joanna, but I'll answer your initial question. If you feel you're being harassed at work, number one, you should speak to one of our lawyers immediately. We will be able to give you the information that you need and kind of handle your specific situation. We will give you an action plan. We'll tell you exactly what needs to be done. Generally speaking, here's the way something like this goes. Number one, you need to report the harassment to your employer. You need to make them aware of the situation, and they should be doing something about it. And actually in Ontario, at least, which is where I practice, in Ontario, employers have an actual positive obligation to investigate and to take steps to try and remedy the situation. Keep in mind, Joanna, you cannot be punished for filing a harassment complaint, even if ultimately you are wrong. And the investigation proves that no, there wasn't any harassment. Maybe it's just a character, maybe it's just a personality conflict or something along those lines. Again, even if you're wrong, you cannot be punished for standing up for your rights to be free from harassment and from a poison work environment. So that's step number one. Make sure you make the company aware of your concerns. They have to try and do something about it, or at the very least, investigate it. If the company does nothing, Joanna, or if you don't feel your concerns are being addressed well enough, you should be speaking with an employment lawyer. And certainly you can reach out to us by sending us an email at help@employmentlawyer.ca, or visit our website, give us a call. Feel free to reach out however you'd like. And if we feel as though, in our legal opinion, of course, that you have grounds for a constructive dismissal on the basis of harassment, then we can get involved on your behalf. And again, either force the company to remedy the situation, or potentially, as you mentioned, claim constructive dismissal and extricate you from that situation, get you out of the poisoned work environment, and get you a severance package, get you a proper severance, and get you moving on with your life, hopefully to bigger and better things. One last point, Joanna, because oftentimes this goes overlooked, and it shouldn't really. Of course, a lot of people that are dealing with a poison work environment get very, very stressed, have a really hard time. It starts to affect their health, mentally and physically. And I wanted to mention that do not be shy to speak to your family doctor about the situation at work. It's actually useful from an evidentiary point of view, because your doctor will, of course, take notes and kind of keep a record of what you discuss with him or her, with your doctor. And that might actually prove useful as evidence. You can also, of course, take a medical leave of absence. If the situation has become so toxic, so poisoned, that you just can't stand it any longer, and you're on the verge of a breakdown, take the time off, take a medical leave of absence. You, of course, need a doctor's note. You should provide your employer with proof that you're on a medical leave of absence, but take that time. There might be disability insurance that you can access, or employment insurance that you can access, financially speaking. You never want to put yourself in a situation where your physical or mental health is suffering because of a difficult work environment. Joanna, obviously we can't get into your specific situation kind of in kind of granular detail. Give us a call, send us an email. Let's have a chat offline, confidentially. And again, we will be able to point you in the right direction. We speak to people every single day, literally, who are dealing with a difficult boss or a poisoned work environment or harassment in the workplace. And we might not have the perfect answer. A lot of times, even with our help, these are still difficult situations. It's hard to get around that, but we will be able to help. We will provide some solace and some guidance about the situation. All right. Keep it going with the questions, guys. I love to see them and I love to answer them. As you can tell, I'm pretty passionate about this stuff, and I don't know much about anything else, but I know a lot about employment law. So you're in the right place if you're looking for some answers. All right, Francis asks, I've been with my company 16 years rather. They put me on job-protected infectious disease leave, which is set to expire on July 3rd. Can your employer at that time put on regular EI for another 35 weeks? I'm from Toronto, Ontario. Great question, Francis. Very timely question, because as you mentioned, you're right. And this is Ontario specific, guys. So sorry for those of you in other provinces, this might not relate. But Francis, The first thing I'll say, and listen, I don't know, and maybe you want to chime in here. I don't know what industry you're in. I don't know what kind of work you do. It would be useful to know because for very, very few industries, and I'm thinking primarily the restaurant business, perhaps some areas of the entertainment business, perhaps also some areas of the hotel industry, the airline industry even potentially. For those very few areas, this infectious disease emergency leave, which was basically kind of this indefinite extended layoff period because of COVID. Again, except for those situations, you're in manufacturing, Francis, that's great, thank you for that. Except for those situations, you actually didn't necessarily need to accept the infectious disease leave or the layoff, shall we call it, in the first place. You could have potentially treated that as what we call a constructive dismissal, which is basically a termination. So you could have potentially treated the initial layoff, Francis, as a termination. Now, that might have happened quite a while ago, right? So maybe that ship has kind of sailed, or maybe you willingly and happily accepted the layoff. Listen, that's okay too if you felt there was a benefit to it. But to your point about this July 3rd date, and yes, as things stand right now, the infectious disease emergency leave is scheduled to end on July 3rd. To answer your question specifically, Francis, I probably would not accept a continued layoff. I'd probably take the position on July 3rd, or I think July 3rd is the Monday, so it would be the Friday of the next week. I'd take the position that you're looking and you're ready to come back to work. And if you don't come back to work, if you're not called back to work, then you should have a bit of a problem with that, because you don't want to accept this extended layoff as a term of your employment. Because as you mentioned, some employers, and I actually think very few, but some employers might actually try and keep employees on a temporary layoff well beyond the end of the infectious disease leave on July 3rd. And some employees might just accept it because they don't know any better. So if you're not called back to work by July 3rd, or again, the Monday of the next week, Francis, give us a call right away. You don't want to wait even a week longer, because that might kind of imply that you've accepted the continued leave. If your employer takes the position that your layoff is going to continue beyond July 3rd, I would take issue with that. But you need legal advice first. Don't contact your employer. Don't respond to them if they advise you that your leave is continuing without speaking to us first. Give us a call, send us an email. help@employmentlawyer.ca is where to reach us. And maybe as a more general point for all of you watching, if you are being temporarily laid off, whether it's because of COVID or not, don't just assume that your employer has that power. In most cases, and there are very few exceptions, but in most cases, your employer does not have the power to temporarily lay you off. You can treat that layoff as a termination. And a lot of times that makes really, really good sense. Even if you're happy with the company, even if they treated you well up until that point, if you accept a layoff one time, you're then giving the company that ability to do it time and time again in the future. And so if next year things, take a turn for the worse and the economy is not great, guess what? They'll lay you off again because they've done it before. So it's not a great idea to be accepting these kind of temporary layoffs as a general point. Again, if you're not sure about any of this, don't take your employer's word for it. Quite frankly, don't even take my word for it here right now. Everybody's situation is different. Make sure you get proper legal advice from an employment lawyer. This is what we do on a regular basis. And so reach out to us. We'll happy to have a chat confidentially and answer your problems. I could tell you from experience, most people that speak to us, they feel better when they're done speaking to us. Again, we might not have every single answer to every single question, but we help more often, much more often than not. So don't be shy. That's what we're here for. All right, what is it? 7:19. We've got plenty of time for question, guys. So let's keep it rolling. I love the interaction. Thank you, Francis, for asking your question, and I appreciate the thanks as well. Zandra asks, I've been with my present employer for 23 years, part-time for approximately 20. Starting in September, they're eliminating part-time, meaning no benefits, no vacation, and you might be losing your pension. Also, no guarantee of hours. What are my rights? I wish I was given a package. I hear you. Zandra, and it sounds like you've received notice of this change, which is interesting. I can tell you, Zandra, that a significant change like that, where you're losing your benefits, you're probably losing your pension, you're losing your kind of guaranteed number of hours, and there won't be a guarantee anymore. That is what we call a constructive dismissal. It's a significant change to the terms of your employment. And if an employee wants to consent to those changes, if for whatever reason this might work out for some employees, Zandra, then that's fine. They can accept those changes. But for an employee who doesn't want to accept the change, they have every right to refuse. And that means that there's either one of two options that are going to happen. If you refuse the change, Zandra, either your employer backs down, in which case your employment on your current terms just continues indefinitely. That's probably the rarer occurrence, but it does happen. The other option is that you would have to claim constructive dismissal, meaning you would have to treat this as a breach of contract, effectively resign your employment, and pursue a severance package. Now, I want to be clear, Zandra, you shouldn't be doing that without proper legal advice. And I know this is becoming kind of a running theme of the evening, unfortunately, but it's genuinely true. Don't resign. And for anybody watching out there, if you think you're dealing with a constructive dismissal, if you think your employer's done something wrong, don't resign before you get legal advice. Trust me, it's going to be worth it. Your situation is actually a touch different, Zandra, because you got notice of the change. So you clearly know that this is happening, and you've been told, it says starting September that this is happening. That notice is potentially something that the employer can hang their hats on, because one of the very few ways in which an employer can get away with implementing a significant change to the terms of your employment, kind of get away with a constructive dismissal, is by providing reasonable notice of the change. And so I'd want to know, Zandra, your position within the company and how much notice you've been given. If it's just a couple of months, if you just found this out now, and there's, what are we, June, July, August, September, maybe about 4 months of notice, well, that might not be enough for a 23-year employee. But if you knew about this last year, for example, well, then that might be a different, a different thing. You may still be able to use this situation, Zandra, to actually leverage a severance package out of the company. If that's something that you would be interested in anyway, we may be able to do that. Because again, even with this 4 months of notice, you can still, and I would do this, of course, professionally and respectfully and politely, you can still reject the change. And that puts the company in a tough spot, because they have to then either force the change on you, which again gives you some grounds to claim constructive dismissal, or they will end up terminating your employment anyways and making you a severance offer. So you have options here, Zandra, because this is likely a constructive dismissal. Help at employmentlawyer.ca, or give us a call toll free. We will put you in touch with one of our lawyers. We can have a chat about your situation, strategize, get you a plan. We can even help out in drafting an email or drafting correspondence to the employer, kind of so that you know exactly what to say and exactly what position to take, and we'll get you on your way to hopefully getting a resolution to this issue. Razor Sharp is back. How frequently is my employer allowed to lay me off if I did accept the layoff? What if I didn't know I was giving them permission to do this in the future? Great question, Razor. And listen, it's tough to say, but really the answer to the question is if the situation is comparable and it happens again, they may have the right to lay you off again. So again, if you were previously laid off because of financial difficulties, because the company had to slow down its operations or something like that, and that happens in the future, they may very well have grounds to do it again. Actually, a good piece of practical advice here, Razor Shop, if you're worried about this, would be if you accepted the layoff and are going back to work, maybe you want to send your employer a very nice, very brief email saying, just so you guys understand, I accepted this layoff strictly due to COVID as a kind of one-off exceptional situation. I don't feel comfortable with temporary layoffs being a term of my employment moving forward. That is going to be great evidence if the company tries and do that again to you. So you're basically putting it on the record that you did this as a one-off because of COVID, because this is an exceptional situation that's never happened before, and that you're not going to be agreeing to layoffs moving forward. That's great protection for an employee against future layoffs. Francis is back as well. When do they have to inform me if you're going back? The week on or after July 3rd? I mean, really, they should be doing it, as early as possible is the reasonable answer, Francis. I mean, if employers are gearing to come back kind of after July, they should be reaching out to their employees, I would say within the next week or two, really. That last week, so that last week starting in June and ending in July 3rd, if you don't know that week, I think that's a massive red flag. So if they don't reach out to you that week, Francis, you should be in touch with us. I would say by the Friday, and I wouldn't really wait, even a week past that Monday. So they certainly should be letting you know in advance. Keep in mind, especially in an industry like manufacturing, they have to create schedules. They have to know who's coming in, who isn't, et cetera, et cetera. Listen, you can also potentially be receiving a severance offer if they don't want you back at all. Something like that could happen. David asks, can you get constructive dismissal off a temp agency if they cut your shifts the last week? Good question, David. Temp agencies are interesting only because almost always, and I would say if not always, temp agencies will provide pretty lengthy, kind of pretty thick employment contracts or employee handbooks to temp workers. And there might be some terms in that document, again, whether it's a contract, whether it's a handbook, there might be some language in that document that allows the temp agency to change your hours, or to even change your position, change the company that you're working with. There might even be some termination language in those documents, requiring a particular amount of severance to be paid. So I think the first place I would look, David, is probably your contract. And if there's language in there that says, yes, they're allowed to change your shifts or they're allowed to change the terms of your employment, you're probably stuck because contractually they would be allowed to do that. It's tough. I get it. And temp agencies are, a bit of a notorious area of law because you don't really know who the employer is. It's the temp agency. It could be the employer sometimes, the company that you're actually working for. And sometimes, it's very, very muddy as to who owes you what and what your rights exactly are. I would start with the terms of your employment contract. And if there's any uncertainty there, reach out to us. We would have to have a look at that documentation, get a better sense of the situation, and ultimately give you our advice. I get it, David. It may very well be no fair. I certainly understand. But if that's what you signed up for when you joined the temp agency, then it's tough to argue something contractual like that. Listen, I don't know that for sure, right? You need to look at the contract yourself. And again, if you have any doubts, don't be shy to reach out to us. We're here to give advice in exactly those kinds of situations. Zandra asked, they might have sent me an email, but at the moment I'm locked out of my workplace account. Well, that's interesting, Zandra. I mean, listen, if they're making a significant change like that, and we're going back to Zandra's situation for all of you viewing, who was dealing with a reduction in her, or a cut rather, not reduction, but a cut to her benefits and a cut to her pension potentially, and also no guarantee of hours. Zandra, the notice that you would have had to be provided of that change has to be clear. So if this is just something you heard through the grapevine, or if this is something that you were, that you were told, but you said, we're not sure, this might be happening, this might not be happening, that's not good enough notice. It has to be absolutely crystal clear that, effective September 1st, this exactly is what's going to happen. And if that's not what's been provided to you, then that notice doesn't count, doesn't affect anything at all. So again, the lesson remains, if that's happening to you, that may very well be a constructive dismissal that gives you options. One of your initial options would be to very politely and professionally say no to the company and say that you're not interested in something like that. And that's what you likely should be doing. Don't do that, Zandra, without legal advice. You need to speak to us first. Iona, you're asking how much does a consult cost? It depends, Iona. So in some situations, we offer free consultations. And so the consultation may very well be free. That's not every situation, however. So for example, if somebody's still employed with a company and still earning a living, a lot of times those consultations will have to be paid. And the amount will depend on the lawyer or the paralegal that you're going to be speaking with. And so if your situation is more geared to maybe someone speaking to a paralegal, I'd actually say the cost is quite minimal. Maybe it's about $100 or so, or something in that along those lines. If you're paying for a consultation with a lawyer, the hourly rates can get quite expensive. It depends on the experience that particular lawyer has. We have consultations ranging from I think $200 or $300 an hour to potentially $500 or $600 an hour. What you can do, Joanna, is give us a call. The initial contact is completely free of charge, and so you can speak to one of our intake team. They will be able to guide you in the right direction and even give you some kind of very basic information about your situation and give you payment options. We are pretty reasonable when it comes to this kind of stuff. You and our office and the intake people can determine what the fee arrangement is going to be. So don't be shy to call us. Don't be shy to reach out to us. Unfortunately, we're out of time, guys. We do this on a regular basis. I think there's another live Q&A coming up tomorrow at 1 p.m. And if not tomorrow, I think there'll be one on Monday. So save your questions. Tune in next time. Look out for employmentlawyer.ca. All of our social media content will be posting the next live Q&A. Again, my name is Alex Lucifero. I'm an employment lawyer with Samfiru Tumarkin. Thank you all for watching. Thank you all for answering your questions. I hope I was able to help even just a little bit. Again, point you in the right direction. Have yourselves a good evening. Have yourselves a good weekend, and we will talk soon. Take care, everyone.